Hey there, I'm estate planning attorney Paul Rabelais, and in this video we're going to talk about some of the benefits and some of the problems with the current guardianship legal proceeding. Some states call it a guardianship, some states call it a conservatorship, some states call it an interdiction. I'll probably refer to it more often than not as a guardianship. But the Brittney Spears legal battle has thrust guardianships or conservatorships in the spotlight, and abusive guardianships can be a nightmare. So here is how guardianships or conservatorships typically work, and know that the rules can and do vary by state. So this guardianship typically starts with someone, I'll call that person the potential guardian, sees that due to another individual who I'll call that person the defendant, the potential guardian sees that another individual lacks the capacity to make responsible decisions. So that potential guardian files a petition at the courthouse, hires a lawyer, files a petition, and in that petition, the potential guardian is asking a judge to rule that the defendant does not have the requisite capacity to make decisions for themselves, and the potential guardian asks that a guardian be appointed to handle, all of the decisions of the defendant. So some people think, a guardianship is final when just anybody files a petition to the courthouse, the judge signs it, voila, it's over. It doesn't quite work that way. So there are protections in place for the defendant when someone files a guardianship petition seeking that, that the guardianship be instituted. So potential guardian files a petition, serves it on the defendant, typically sheriff's service, to make sure the defendant actually gets it. The defendant must be represented by a lawyer, either the attorney of the defendant's choosing, or if the defendant doesn't hire a lawyer, a judge will appoint an attorney to represent the defendant. And then the defendant answers the petition, and then typically there's some medical examinations or reviews of medical records, and all of that leads up to a court hearing where it's required that the potential guardian be there and the defendant be there. They're all represented by lawyers. There's a hearing, a judge oversees all of that, and then a judge rules. And a judge rules either that the defendant has the capacity to make decisions for themselves and no guardian is needed, or the judge rules that the defendant lacks capacity to make their own decisions and a guardian is appointed. Now, because the effect of a guardianship is to take away someone's ability to make decisions for themselves, it's a big deal. But when handled well, it's really beneficial for families. A guardianship can prevent someone without a certain baseline of capacity from making decisions that would harm themselves. And if the right guardian is appointed, then the decisions the guardians make, whether they are financial decisions, healthcare decisions, or other life decisions, those decisions that the guardian make allow the individual or the defendant to have quality of life. But when problems arise, that's when guardians overstep their bounds, because in many circumstances, the guardian is trying to gain some financial advantage by being the guardian, or in extreme cases, the guardian is looking to extort money from, I'll call it, the defendant. And when there is abuse, it's difficult to remedy because the defendant is often old and the defendant just doesn't have the fight in them to defend themselves in that guardianship proceeding. So the intent is to protect the money and property of people who truly cannot make decisions that are in their best interests. But the problem is the result of the way our guardianship laws are currently structured often result in greater harm to the people the laws were intended to protect. So there are likely to be some improvements made to our guardianship proceedings. Some of those improvements that may be suggested include bonding requirements for guardians or conservators, as they're called in many states, perhaps training for guardians or conservators, perhaps greater penalties for those who take advantage of the vulnerable, perhaps increased review of guardian annual accounting reports that are required to be filed by the guardian, or just, quite frankly, more review of the guardian or conservator's actions. But many power of attorney documents, this is where we get into some of the things you can do to perhaps, prevent yourself from being taken advantage of in future years. Many power of attorney documents allow you to designate who you want to be your legal guardian in the event you are determined in the future to be legally incompetent by a judge in a court process. So you'll want to make sure you get your financial power of attorney, or some people call it durable power of attorney, general durable power of attorney. Make sure you get those documents in place along with your healthcare power of attorney, or in some states it's called an advanced healthcare directive, so that you get to control while you're able, while you have good capacity, you get to control who you'd want making your financial decisions and your medical decisions if you get to a point where you can't make them for yourself. And you can also designate in those legal documents who you'd want to be your legal guardian in the event someone files a petition at a courthouse and successfully asserts that you're incapacitated. You get to determine who that court-appointed guardian will be, because many states allow you to do that in these power of attorney legal documents. So it'll be interesting to see how all of this plays out. There's going to be some congressional hearings. The Brittney Spears case really thrust guardianships and conservatorships into view. We'll see how it goes. If you've had some experience in the past with guardianships or conservatorships, let us know in the comments below. Make sure you like, share, subscribe, all those good things. We'll see you next time.